Hello, my name is Tyler, and I will discuss immigration laws for employers and employees. Table of contents. Here's what's going to guide this presentation, starting with the Immigration and Nationality Act of 1952, or INA, Title VII of the Civil Rights Act of 1964, Executive Order Number 11246, Immigration Reform and Control Act, or IRCA, Immigration Act of 1990, and wrapped it up with Deferred Action for Childhood Arrivals, or DACA. The Immigration and Nationality Act of 1952. The INA collected many provisions and reorganized the structure of immigration law. The act abolished racial restrictions found in U.S. immigration and naturalization statuses going back to the Naturalization Act of 1790. However, the 1952 Act retained a quota system for nationalities and regions established by the Immigration Act of 1924. Therefore, it reinforced a controversial immigration selection system in which some ethnic groups were desirable immigrants and emphasized labor qualifications. Regarding the preference system, the Act eliminated the contract bar and placed employment based preferences for foreigners for economic potential, skills, and education. Title VII of the Civil Rights Act of 1964. Title VII protection covers the full spectrum of employment decisions. Federal labor and employment laws generally apply to all employees regardless of an alien's immigration status. National origin discrimination includes less favorable treatment of an individual because of their ancestry or a particular national origin group's physical, cultural, or linguistic characteristics. Executive Order 11246. This executive order, similar to Title VII, prohibits federal contractors from discriminating based on race, color, religion, sex, sexual orientation, gender identity, or national origin. It requires affirmative action to ensure equal opportunity in all employment aspects. In addition, contractors must draft written affirmative action plans and take positive steps to eliminate employment bias. In return, it increases workplace diversity and the participation of minorities and women. Regarding sanctions, the order bars contractors failing to comply with affirmative action obligations from contracting further with the federal government. Immigration Reform and Control Act of 1986. The IRCA changed U.S. immigration law by making it illegal to hire illegal immigrants knowingly and establishing financial and other penalties for companies that employ illegal immigrants. These sanctions will apply only to employers with more than three employees and did not make a sufficient effort to determine the legal status of their workers. The act also legalized certain seasonal agricultural undocumented migrants who entered the U.S. before January 1st, 1982, and have resided there continuously without a fine. Additionally, candidates were required to prove that they were not guilty of any crime and possessed minimal knowledge of U.S. history, government, and English. Regarding Form I-9, in theory, financial and other penalties will reduce undocumented migration. Consequently, the Act introduced the Form I-9 to ensure that all employees presented documentary proof of their legal eligibility to accept employment in the U.S. According to one study, the IRCA caused some employers to discriminate against workers who appeared foreign, resulting in a slight reduction in overall Hispanic employment and wages. The Immigration Act of 1990 was a national reform of the Immigration and Nationality Act of 1965. It provided family and employment-based immigration visas categorized by occupation and a diversity visa program that created a lottery to admit immigrants from low-emitted or underrepresented countries in the U.S. EB-1 visa. The EB-1 is a preference category for U.S. employment-based permanent residency intended for priority workers, and other qualifiers include spouses and children. It allows foreign nationals with exceptional skills, including professors or researchers, and some executives and managers of foreign companies, to remain permanently in the U.S. EB-2 visa. An EB-2 visa is an employment-based visa available to non-U.S. citizens with an advanced degree or exceptional ability. An EB-2 visa holder is considered a lawful permanent resident of the United States. These holders are experts in the sciences, arts, or business that will give much leverage to the national economy, cultural, or educational interests or welfare of the United States. Moreover, employers in the United States seek these services in their areas. A national interest waiver requests that the labor certification exempts it because it is in the interest of the United States. The applicant applying for release should meet the requirements above. Deferred Action for Childhood Arrivals, DACA. DACA is a U.S. immigration policy that allows some individuals with unlawful presence in the U.S. after being brought to the country as children to receive a 2-year renewable period of deferred action from deportation and become eligible for a work permit in the United States. An employment authorization document, commonly known as a work permit, provides temporary employment authorization to non-citizens. Research has shown that DACA increased the wages and employment status of DACA-eligible immigrants and reduced the number of undocumented immigrant households living in poverty. Combating the notion that DACA recipients are stealing jobs away from other Americans, economists reject that DACA has adverse effects on the U.S. economy or labor market outcomes of native-born Americans. This slide concludes my presentation. Thanks for listening.